Thank you very much, viewers. Once again, I welcome you to our class. And today, we shall be discussing on the law of contract. This is a very important topic, especially for all students who are taking business courses, and more so, accounts, diploma, and CPA. So under this topic, I'll be discussing on the various elements. Number one, I'll be talking about type of contracts. Then also essential of a valid contract. I shall also speak on vitiating factors or vitiating elements. And then lastly, I'll be discussing on the remedies for the breach of contract. So by definition, a contract is simply an agreement that is legally binding or enforceable by law. A contract can only be a valid contract if it is enforceable by law. So in other words, we say a contract can only be valid if it has all essential elements that we are going to discuss ahead. So according to the definition above, a contract can only exist when there is two factors. Number one, an agreement. Number two, the agreement must be enforceable by law. So if the relationship that exists between two parties cannot be enforceable by law, then that relationship is declared null and void. Let us now look at the second element, types of contract. We have various contracts under this topic that we are going to highlight. The first one is what we call express or implied contract. So an express contract is a contract which parties involved specifically agree about the nature of the contract. For example, if A is selling his item at 100 shillings and B accepts to buy the same item at 100 shillings, then we can say that is an express contract. Number two, we have unilateral contract. A unilateral contract is one which only one party is bound. So in this case, this is a rare type of contract. For example, where there is a reward. For example, sometimes you can say, if you can recover my lost item, then you'll be able to get 100 shillings as a reward. So that is what we call a unilateral contract. Contract number three is what we call a valid contract. A valid contract is a contract which is enforceable by law. Whereas a void contract is a contract which cannot be enforceable by law. Number 5, we have what we call contract of ebarima fidei. Contract of ebarima fidei. This is a contract where only one party has full knowledge about the subject matter under the agreement, and he has a duty to disclose it. He has a duty to disclose the same matter. This is an example of a contract of insurance. We call it a barima fidei, or in other words, it is also called a contract of utmost good faith. Number 4, we have what we call contract of record. Contract of record. This is a contract that exists when one enters or files a case at the court of law. We can say that is a contract of record. It only comes to existence when an individual files a case at the court of law. It also contains the judgment at the court of law. Those are various contracts you can discuss. There are very many, but the ones I've talked about are the ones that are common, used under the common law. So our next subtopic, we have what we call essential of a valid contract. These are the factors that make the contract valid. Because as earlier we earlier discussed this contract, we said for a contract to be valid, it must be enforceable by law. So there are certain essentials that we normally consider. Number 1, we have offer and acceptance. For the contract to exist, there must be a lawful offer and a lawful acceptance. This means that if the elements that are before the contract are not lawful, they are declared null and void, and therefore they cannot be enforceable by law. So for the contract to be valid, the first thing, it has to have an offer and acceptance. There must be somebody who is willing to offer something. At the same time, you must have somebody who is willing to accept the offer. Number 2, for the contract to be valid, the parties involved should have the intention to create legal relation. So if there is that factor missing, then that contract cannot be valid and it is declared null and void. Number 3, there has to have lawful consideration. Lawful consideration. Consideration means the price paid by the offer. So what is it that you are paying for the contract that you're just entering into. So factor number 3, is saying that it must have lawful consideration. Number 4, we have the capacity of the parties. For the contract to exist, the parties involved must have the requisite capacity. For example, if you have taken a tender to supply cement to a certain factory, let's say 5 tons, then you have that financial soundness that you are able to supply within the agreed period. So for the contract to be valid, the parties involved should have what we call the capacity. Do you have what it takes in order to supply what the client is willing to offer? Number 3, lawful object. For the contract to be valid, there must have a lawful object, which means the item that is being brought out for the contract to exist, it must not be one that is void, which means it has to be something that is acceptable by law, something that can, in case of any breach of contract, you can claim or you can be given compensation at the court of law. Another point is possibility of performance. Possibility of performance. For any valid contract to exist, the parties involved must have the capacity of performance, which means if the item that before is being brought before the contract is one which cannot work, then it is declared null and void, and therefore it affects the performance of the contract, and therefore it is unacceptable in law. In our next subheading or subtopic, I'll be discussing the vitiating factors. Somebody may ask yourself, or a common man may be looking at, what are these vitiating factors? Vitiating factors are those factors that affect the validity of the contract. So in law, we say these are vitiating factors. These are the factors that affect the validity of the contract. Because a contract to continue or to exist, there are some factors that normally affect. So under vitiating factors, there are around 5. Number 1, we have mistake. Number 2, we have misrepresentation. Number 3, we have illegality. Then number 4, we have what we call undue influence. Then number 5 is what we call duress. Duress. So we shall start by explaining what is meant by what we call mistake. So what are these things that affect the validity of the contract? If there is a mistake, maybe the contract that was entered into, they can sell, it was by mistake. And this mistake can be mistake of law or mistake of fact. Mistake of fact is where the agreement that was signed, maybe it was by mistake. And therefore, if a contract was signed by was entered into, it was by mistake, then it renders the contract voidable at the option of the affected party. So if a contract entered into it was by mistake, then it affects the validity of the contract. Number two, we have what we call illegality. Illegality means that the contract that was entered into, it was illegal. And anything illegal in law, it cannot be enforceable. It is declared null and void, hence affecting the validity of the contract. Another mistake or another factor you can say it is duress. Duress in law, it just means that if the contract that was signed into it was by either violence or it encompasses some threats. Therefore, the affected party may say, I only signed this contract under duress. It was under influence of a superior individual, because we have some people that are superior in organization. So therefore, they may force their junior to sign some contract, but he can just say, I signed under duress. That one means that there was influence. He signed that contract under influence, or it was under threat. Therefore, it affects the validity of the contract. So our next subtopic, under this topic, we can say we shall be discussing the discharge. Discharge of a contract. Discharge means how can this contract come to an end? Because contracts are normally assigned for a certain period of time. So when that time elapses, then you can say that that contract has been discharged. So there are normally 5 ways through which a contract can be discharged. Number one, that is performance. Number two, by agreement. Number three, by frustration. Then number four, by breach of contract. Then number five, discharge by operation of law. So how can a contract come to an end? By performance. We can say that a contract has been discharged by performance if the parties involved have performed their contractual obligation, and therefore no one remains to perform his duty. If A was given a mandate to supply books to a certain institution at the cost of 4 million, then A supplied the books and then the institution paid. Therefore, we can say that that contract has been discharged by performance. No one is there, or no party has failed to perform his contractual obligation. So we can say that a contract has come to an end by performance. Number two, by agreement, discharge by agreement. This is where the parties involved have signed a document concerning the contractual obligation of their dealings, and they have agreed that to end their relationship because of maybe A, B, C, D. So we can say that the contract has come to an end by agreement, which means the parties involved must agree. And in law, we say they must have, they must be at idem. Idem meaning it must be, they must have same mind. So they have agreed, and therefore a contract can come to an end. Then we have discharge by frustration. This is where a contract has not come to an end, but a frustrating event occurred on the way, making it difficult for one of the parties to continue. And therefore, we can say that this contract has come to an end due to a frustrating event that happened on the way, rendering it impossible for the contract to continue. Then we have what we call discharge by operation of law. This is where a contract comes to an end under the following four circumstances. Number one, lapse of time. Remember, contracts are assigned for a certain period of time. So when that time expires, then that contract, we can say it has come to an end due to lapse of time, since contracts are made for a specific period of time. Number two, death. When death has occurred to the either party, it makes it impossible for the contract to continue. Why? Because one of the parties has died. Therefore, it is declared null and void. Another one is bankruptcy. This is where one of the parties has been declared bankrupt by a court of a competent jurisdiction. And in this case, this is the High Court. This is only the High Court that has been vested with the powers to declare an individual bankrupt. Therefore, if any of the parties has been declared bankrupt by a court of competent jurisdiction, then you can say that this contract has come to an end by operation of law. Then the last factor is what we call substitution. If the parties involved have substituted the earlier contract with another subject matter, that contract comes to an end by substitution, and therefore rendering the contract null and void. Therefore, those are the ways through which contract can be discharged. However, we can say that anything that is good has always the negative side. So the last subtopic under this headlines, I'll be handling what we call the remedies. Remedies for the breach of contract. What is it that is there if somebody fails his contractual obligation on his part? What are the things that the affected party may be able to gain? So whenever there is a breach of contract, the injured party becomes entitled with the following remedies. Number one, damages. Damages in law are monetary compensation for the breach of contract. So the injured party to the contract will be rewarded a monetary compensation, and therefore we can say that it has been damages given to him because for the breach of contract. So under the breach of contract or under damages, there is what we call monetary compensation. Another factor is injunction. An injunction is simply an order restraining the party involved from doing or from participating in a certain transaction. Therefore, the court will issue an injunction. This is just an order to stop that transaction until the matter is heard and determined by the court of law. So we can say that that is what we call an injunction. Another one, specific performance, is also a remedy under the law of contract if the party have failed to perform his contractual obligation. This is simply the equideporymity in law. This is where the parties are forced to perform the work that they entered into with the injured party. For example, if A and B entered into an agreement for clearing the bush, and A agreed at Kenya shillings 500, and B also agreed to pay him when he finished his work. But upon payment within reasonable time, maybe A failed to perform his duty within the reasonable time allowed by the court of law. Therefore, the court will force or will institute this remedy of specific performance for the order, for the work that was supposed to be done by this particular individual. So that is also a remedy under the breach of contract. So the last remedy that is applicable under the breach of contract is what we call quantum meruit. Quantum meruit. This is the remedy that is there, especially when the contract has involved the third party. The injured party against the guilty party. So the parties involved will institute the quantum means proportion to work done. Proportion to work done. So we can say if A agreed to till a half an acre land at Kenya shillings 5,000 within reasonable time given, let's say 2 weeks. Upon the expiry of 2 weeks, A was only able to till a quarter land and he could not be able to finish. Therefore, the injured party will file for quantum merit. He will only be paid that which he performed, and that making the contract to an end. Thank you so much, viewers. That was the law of contract. If you have any question, you are free to ask, and we shall be able to enjoy our class. Let's meet next time as we continue this topic, especially this time when the candidates who are taking CPA are preparing for their exams this December. Have a blessed evening. Yes, klasi yangu imeisha. Niko nao wameshinda tu wakili. Unaona hata huyu mwingine nilikuwa klasi na haka anapika simu. Yeah. Ameshinda tu kupiga simu na hii imekuwa 33 minutes. Unajua natakanga topic moja iishe. so that if somebody is making some short notes anatengeneza tu short notes hivyo. Unajua kuna watu wengine wako job hawana time ya kuingia class, na kama ako na wifi anaingia tu. Hello. Niko na mama akaba kotini anafanya CPN. Tulianza kufundisha na simiti akaenda na akaajia kwa njia. Mwambie tu ajoin class amtafutie notes. Class imeisha bana. Leo imekuwa mrefu, 33 minutes ni mingi. Tulikuwa tunafunza online watu wetu wakati wa COVID. Sasa mtu unajua wewe umemuona anakimbia ako uji, alikuwa anapika hao sekretari hao ukajazi ona tu kitu watu kama Umanya hadi hao ndio sekretari umeandika kazi anaweza pika mteja. Mimi anaweza pika mteja. Hello? Yes? Hawa ni watu wamemaliza mtihani wanatafuta fare. Mtoto ametumiwa pesa na hata ananipikia. Mtihani imeisha. Aja nikwambie siku nyingine chesi. Tulikuwa na simiti bwana. Tumesota. Sasa tumekaa hapo na mtu akatuma pesa hapo 5,000. Simiti akasema hizi hata sasa sirudishi. Aje kwanza nisiweke kwa mshwari tulipe madeni. Wakitaka kureverse. Tukakaa wanao inaisha. Hakuna mtu mwenye anadai hiyo pesa. Kumbe mwanafunzi wetu amelipa school fees. Na sisi amelipa school fees. Na ametumia baba yake ndiye amelipa. Sasa sisi tunasema huyu mtu ametuma pesa wrong number. Sisi tukagawana kwanza tukakula, ndio kesho yake mwanafunzi ndiye anapiga simu ati baba alituma school fees. Ni wali ile kati. Sasa wamemtumia pesa tena flash. Nyani nambe yo mlo sio wako sana. Alo zai no ka akubonera. Sinjo musirese yakolana cyo kumunya wata. Mala abone ngorumira anzo route na Kenya mara zo nachota. Mimi niliomba mzee pesa anipatie tu 200 pocket money, niko shule akaninyima. Sema wewe hakuna pesa. Sema sawa. Na yeye alikuwa ametoka kukunywa na ameacha koti. Alitoa koti na akaacha tu kwa kahawa tulikuwa tunavuna. Sasa mimi kuenda kuangalia hiyo koti nikapata iko na 1,500. Wale wako loriera. Sikia niweza amehoni ya ile koti ta. What I did, nilichukua hiyo koti na pesa na nikaenda naye kwa nyumba. Nikamwambia nimeokota hiyo koti na ilikuwa na pesa nyingi. Sasa unajua ili niona ananipatia ama anipatie. Na akanipatia 500 kwa sababu alikuwa ameninyima. Hello? Sawa, unajua zile credo wewe. Ujana hujatoka Yes, simu yako iko na minutes. Sasa hii sitaki. Lakini inasumbua itach. Unataka tu call kwa namba yenye kwa screen. Kama unaweka namba hiyo. Sisi ile imepasuka mbaya. Sasa huyu anataka nini? Mimi sina pesa sasa. Mtoto alimtumia pesa ya kuja nyumbani. Maliza shule hapa KBF tu. Hapa KBF 500 hizi ni mola kabisa. Nakiweka box kwa gari. Na kutoka hapo kuja misigo ni 150. Box wamlipisha maybe 100. Sio ni 250. Tuna anaitisha nini ananipigia nini? Kama ni sikula geja aliyebusuma. Ukitimaniza yako amalani. Lazima mamalizia amefanya. Amefunga hii term. Next week si watu wako na kuja. Mbona kiuko zile kuzimara kama